Hello and welcome to Piece of Pod, a podcast brought to you by South Coast law firm Warner Goodman. I'm Sarah Whitemore. I'm an employment lawyer and senior partner in the firm with over 30 years of experience. In this podcast, I'll be having conversations with law firm partners, business owners, clients and other contacts of mine, and we'll be engaging in conversations about running businesses, career journeys, and how to excel in the world of work. So if that's of interest, why not grab yourself a cuppa, get yourself comfortable, and let's dive in. In this episode, I'm joined by a lawyer from our private client team in Fareham. We'll find out a little bit later about what private client actually means. But Karon joined us from an unusual journey. She started off at schools and colleges in the Portsmouth area. Then she joined the police and moved to the Midlands. And now she's back in Fareham as a private client lawyer. So thank you for joining us today, Karon.
Thank you for inviting me.
So you've seen some of our podcast episodes before, so you won't be surprised that the first questions I'm going to ask are all around your journey and how you came to join Warner Goodman. So let's start with that. How did you become interested in the legal sector?
When I joined the police, obviously I did a lot of law around, obviously criminal law at that point, but I sort of realised that it probably wasn't my passion, but I was really interested in law, so I decided to do some qualifications to work out where I wanted to go. I was pregnant, I had children, and so I started going to night school, started off sort of O-levels back in the day, A-levels back in the day, and then moved on to a pathway through Silex, which is sort of a degree in different areas of law. So that's where it started.
Right,
and
so
then...
just
Yes.
unpicking a bit of that. So
Yeah.
you started off as a police officer, actually
I did,
out on the beat or in the
Yes,
CID, or what sort of policing?
No,
you
I
do?
was, so I did 10 years in the police.
Mm-hmm.
So I was on just general policing duties.
And then the police supported you to become a lawyer, or did you do that independently?
No, I did that completely independently. So when I had children, when they were young, I went part-time, and whilst they were growing up, I was then separately studying as well. So
the police kind of gave you that initial interest in the law,
Yes.
but then you went on to do the studying.
Yes, correct. So once I had qualified through the Silex route, which is the Chartered Institute of Legal Executives, so once I had qualified in that area, I then decided I wanted to go into law. So I applied for some jobs, and I was very lucky to be taken on by a firm in Kettering in Northamptonshire, and then they developed me and sort of trained me up, and I sort of fell into the private client area.
So was that just because that firm had a vacancy in that area?
Yeah.
And so back in those days when you came through that route, it was quite an unusual way to go, I would imagine. Today we have lots of different opportunities.
Exactly.
We've just launched our WG Academy with people who are going through the SQE Solicitors Qualifying Exam, people who are going through the traditional trainee solicitor, still Silex people who are apprentices. But back then it was a very clear division between you were either a solicitor and you'd gone to university and done the academic route, or you were Silex or a legal executive, and then you came through that route. But firms weren't all open to both areas, were they? So
no, back in then, obviously regulations have changed over the years. I think going back to 2017, I think when it changed, where you couldn't be a partner if you went the Silex route, you were not necessarily on the same level as the traditional degree route, solicitor route, but in 2017 that all changed and the regulations changed, which made it a lot easier for the Silex to be sort of deemed on the same sort of level, although you've gone through different paths. But back then it was very heavily focused. You had to do it. You did your day job, but you then had to go to it night school, or you did it distance learning, which I did. I did both. I went to college, and then I did distance learning. And having two small children at the same time. So
you've not chosen the easy route then,
I
have
did
you?
it. It was not necessarily easy, but but rewarding. Certainly, being able to sort of progress and get qualified. Yes, it was very good.
And so you got your initial interest in the law. You get your qualifications, and you found a job. How did you end up as a private client lawyer?
So initially I was working for the company commercial team actually when I first started for the first 6 months. And then one of the private client lawyers was retiring and they were looking for somebody to replace her. And she had specifically dealt with quarter protection, which was the old form of quarter protection. I mean, the law has moved on and completely changed as it is now. But it was not it wasn't an area a lot of people really wanted to do because it seemed to be a little bit sort of, not very popular at that point. So they basically asked me, would I be interested in taking her role and focusing on quarter protection in the private client team. Obviously still doing the general basis of private client, which is wills, probate, powers of attorney at that time. And so I sort of fell into it really and sort of made my career out of doing quarter protection. That's where it started from.
And a lot of our audience for our podcast are business owners, HR managers, other professional people. So the term private client isn't necessarily known to them. You've explained there a little bit. It's wills, trusts, probate, that sort of thing. The term court of protection is definitely not known to everybody. What is the court of protection? What's that all about?
So the court of protection is a specific court. It's part of the family division. And the main base of the court of protection is in London. But it mainly focuses on areas where people have lost mental capacity. So for whatever reason, so you'll have sort of two types of people that lose mental capacity, maybe through a brain injury or an accident or something like that, or you'll have the older type client where unfortunately maybe they've got something like dementia, Alzheimer's, or something has happened, maybe vascular issues or something like that, where they are not able to make decisions for themselves. And one of the problems that happens is that people don't really plan for the future, because not necessarily why necessarily you would think to plan for your future, but if you haven't made what's called a lasting power of attorney and you lose mental capacity, the only route you've got for somebody to be able to make decisions for you, because you can't make those decisions yourself, is to apply to the Court of Protection, which is part of the High Court, for an order to be able to act on somebody else's behalf for decision making. And that decision making will be either on financial decision making or health and welfare decision making. So on a specific health and welfare decision.
So we traditionally have encouraged people to write wills.
Absolutely.
And that's providing for your dependents after, or charities or whoever it is you want to provide for after you've died. And often we come up against the issue that people who are in their 20s don't think about writing wills because I'm not going to die till I'm in my 90s, so why would I do that now? But these power of attorneys that you're talking about are really going to be relevant to anybody. It could be anybody who walks under a bus at any point and suddenly they need to have decisions made on their behalf.
Yeah.
And you're a professional deputy.
I am.
Is that part of this court of protection?
So some people unfortunately don't have somebody that is either willing or able to take on the role as what is called a deputy. That is somebody that makes decision on behalf of the incapacitated person. So that deputy will normally be a financial deputy generally. So sometimes there isn't anybody to take on that role, or there is family dynamics, so that family dynamics might cause a problem for somebody in the family to take on that role. So it might mean that somebody independent might need to take on that position. So therefore, if either the person hasn't got anybody or there is nobody willing or able to take on that role, then either the court will approach a deputy and say, would you take that role on? Or, you know, as we've gone through the process and of trying to identify somebody, it's actually more appropriate for a professional deputy to take on that role, then I will then take on that role on behalf of that person.
So if I understand it correctly, then if I write a lasting power of attorney, I would appoint my own person who will be my power of attorney. That will be the person who makes those decisions. Yep. If I don't have a power of attorney and it has to go to Court of Protection, then that's when a professional deputy would be appointed instead of my attorney.
Yes, so basically if you a power of attorney, you are making that specific decision about who you trust and who you feel is the most appropriate person to be able to manage your affairs and make decisions, whether that is financial or health and welfare, about you if you're unable to make the decisions. If you haven't created that power of attorney and you haven't made or delegated, that's the person I would like, then you potentially have a problem, because then you've got to go to the Court of Protection and then it's identifying, you know, because you can't make the decision, somebody's got to make that decision. Who is that appropriate person to then become the deputy? And if there is family problems or family dynamics or there is disputes, then the likelihood is an independent deputy will be appointed by a judge.
And the sorts of decisions that are being taken on people's behalves, a contact of mine was saying about her ex-husband, actually, who developed some form of dementia, I think Alzheimer's, but I'm not sure. And his son then went on to have children, and they had to go to Court of Protection to get the ability to deal with his financial affairs because he didn't have powers of attorney in place. When his son had his baby, ordinarily he would have asked his dad, well, would you buy him a pram, or could you buy some clothes or whatever it was, but they then had to go back to the court effectively to make these decisions, and of course that's very time takes a long time.
It does. Yeah, I mean the court protection applications after COVID, they dreaded word COVID, but after the COVID situation, the court process was in a bit of a mess, and we were taking up to 12 months to get a court order from the court. It has improved slightly now, and we're probably still looking there around about 6 to 8 months. So it's not an easy process, and it's not something you could be left in a situation when there's nobody able to make decisions, certainly financial decisions specifically, until probably 6 months. I mean, health and welfare might be a little bit different because they tend to, any application to court might be quite urgent, so you might get that quicker. But even so, any application to the court is going to take a long time.
So if you have a power of attorney in place and you lose capacity, your attorney can start making decisions on your behalf the very next day, presumably. The speed is much quicker.
Yeah, so if a power of attorney has been created, a lasting power of attorney has been created, and it's then been registered with the Office of the Public Guardian. So the Office of the Public Guardian is part of the Ministry of Justice that regulates powers of attorney and also regulates court protection to a degree. But once it's registered with them and they've stamped the document and it's come back to you, it is a completely valid document from that point. So once it's registered and your loved one or whoever has lost capacity, you can immediately start making decisions on that day. But you do need to go through the registration process. You can't just create the document and then do nothing. You've got to get it registered. And once it's registered, yes, immediately you can make decisions.
So then this is all about planning ahead, isn't it? This
Absolutely.
is all about building that time in. Obviously, none of us know when we might lose mental capacity, but it's making sure that we've done these things in preparation in case we should need them, and just put them in the drawer and hope you never need them, but at some point
absolutely.
It might come to light. Yeah.
And also, I think some of the younger generation, it's also getting their family members as well, potentially their parents or their loved ones, to make these declarations, because they might have to take over their affairs potentially. Unfortunately, I've had it in my family. My stepmother and my father both have had dementia, and but because we've put the documents in place, I've been able to immediately step in and be able to communicate with social services, with the hospitals, with the doctors, and they will ring me and ask for decision making on decisions that need to be made. So it's such a powerful document, but it's so important to make sure to safeguard decision making about you when you can't make those decisions.
And with wills, it's very sort of black and white, isn't it? You're either alive or you're not, and so
Exactly.
your will comes into effect or it doesn't. But with powers of attorney, these could be relevant if you have an accident, if you have a stroke, if you, as you say, dementia. There are all sorts of different ways that your mental capacity could be affected, and means that you still need somebody there to help you.
Yeah, absolutely.
So, do you have any, obviously without disclosing any client confidential information, do you have any sorts of situations where you've helped clients that you can talk about?
Obviously, a lot of clients come to us when they're in normally a crisis situation, mainly around the court of protection area, because obviously if they've already created a power of attorney, then normally that's fine, they can just run with that. But the kind of clients that come to me is when generally their parent has had a stroke or dementia and they're in hospital, and they just don't know what to do. They're in that situation, it's panic mode. Their loved one's poorly, they've got to make decisions about their health and welfare, they've got to make decisions about potential care planning, future planning, get access to their funds, their money, because they've got to pay potentially for care fees. So generally I have a lot of clients in that position that come and ask, what do I do? Where do I go? I need help. And unfortunately, the Court of Protection it's very heavy paper-based. There's a lot of documents, a lot of forms, a lot of processes to go through. It's not as easy to get a court order, and there's a lot of work that has to be done to be able to get it. So I just really enjoy helping to put people on the right track, get them the documents they need, so then they can make sure that they're making the right decisions for their loved ones.
And with the powers of attorney, if you leave it until they've lost mental capacity, they can't then make the power of attorney. They have to have mental capacity to be able to do that. Yeah,
absolutely. So they've got to, obviously, if somebody has potentially early onset dementia, that doesn't mean they can't make a power of attorney. It's about whether they understand, they have the knowledge of what they're doing, who they're appointing, and what the legal document means. So if they can have that high bar of knowing that information, there shouldn't be able to stop them making a lasting power of attorney. But it's when it moves over to the situation where you potentially go and sit with a client and potentially somebody say, oh yeah, they've got capacity. But when you go and you tick off do they know what they're doing? Do they know what that document's about? That legal understanding of what power they're giving? Quite often that fails, and that then means you then have to move over to the Court of Protection. And there is no other choice. It's either you have a power of attorney or you have the Court of Protection. There is no in between.
And so I think about my own situation. My mum has Alzheimer's, and she's been deteriorating for about the last 7 to 10 years, really. In the early days, we noticed some odd things that were happening. Yeah. So, my mum and dad went out for a meal, and I said, what did you have to eat? And she just couldn't remember what she'd had to eat. And eventually she tracked it down and said, oh, it was a fish. Now, my mum of old would have known exactly what type of fish, if it was a plaice, if it was trout or whatever. So in the early days, it was just little things that were disappearing. So I guess at that stage, she would have had mental capacity because you would have talked. Whereas now, she's deteriorated to quite a degree. She struggles with mobility, she struggles with all sorts of different things, but certainly her mental capacity is gone. But presumably on that journey, there would have been a point where you could still have supported.
Absolutely.
With your parents.
And again, I've had the same situation with in my family as well. It's that recognizing that something's not quite right. A family member starts acting a little bit oddly, you've mentioned, and it's at that point is to have those conversations, sit down with your family members, and have conversations about what would you want to happen if you did lose capacity. What are your wishes, feelings, and beliefs? Can we have a safeguarding document just sitting in that drawer, just in case, to protect any event of any situation where you lose mental capacity? And if you having that conversation early enough, then you're safeguarded, and your potentially your loved one is safeguarded. And it's just making sure that planning is put in place so that you don't end up going down the court of protection route, because it's not an easy route. That route, there's a lot of work, and you have to do accounts every year. There's a lot involved.
And presumably it's more expensive?
Yes, unfortunately it is, because there's so much work that needs to be involved in getting that court order. There's court fees as well, and then when it moves over to the Office of the Public Guardian, who's the supervising body for deputies, you've got to pay them fees as well, and there's supervision fees every year. There's deputy bond fees, so significant increase in costs.
So a conversation at that early stage. Now, when my mum was forgetting what she'd had for lunch, it could have been that she was going through menopause and that she just needed a bit of HRT and she'd come back. But you could have had a conversation at that stage that said, actually, we need to be thinking about it now. Even you don't have to be saying to your parents, I think you've got Alzheimer's, you're going to lose capacity,
exactly.
let me have control of your finances. You could just be saying, actually, let's think ahead here.
And I think it's a good conversation, because a lot of people do wills. Well, I say a lot of people, I think it's roughly around 54% of the population has a will, but I think it's around about 18%, 19% that has a power of attorney. But really, if you're going to do a will when you die, okay, that's about making decisions after death, and you're not here. But a power of attorney really affects you personally. It's a very personal document, because you are still alive, and anything decisions are made about you is going to affect you personally. So when you're doing a will, really you need to be considering a power of attorney at that time as well.
So the will's just looking at dividing up your assets once you've gone. And if the family decide to divide it a different way to you, you're probably not at that stage it's not going to impact on you in any way. But the power of attorney might be relevant for, do you want to spend money on this care home or that care home? Do you want this type of treatment or that type of treatment?
Correct.
What sort of quality of life do you want, and how much do you want to spend on it? And those are the sorts of decisions. And presumably, certainly for me, I would want those decisions to be made by my nearest and dearest, and not by some distant court or professional deputy.
And I think one of the things around the health and welfare power of attorney, which is incredibly important, is that you can't get a like-for-like order through the Court of Protection. So doing a health and welfare power of attorney is so personal to you. It's about where you live, like you said, which care home, what decisions, healthcare decisions. And if you haven't got one, and you haven't made a power of attorney appointing the people you trust, potentially the decision makers are doctors for healthcare. So it's doctors that will make healthcare decisions, but things like where you live, what care home you go into, potentially those decisions will be made by social services, not necessarily your loved one, because the decision maker is the doctor or the social worker, not your loved one. The loved ones will get asked questions, about what their views are, but they're not the decision makers. And that's a really important distinction to consider around health and welfare, because social workers tend to be on sort of like limited contracts. You get a different social worker, they come in and out. That person doesn't know you. They don't know your wishes, feelings and beliefs. They don't know what you would want. And I just find it strange that that you wouldn't want the person that you trust the most to make those decisions, probably because they don't know, to be fair. They don't realise that. People wouldn't realise that the decisions wouldn't be made by your family, because they not necessarily wouldn't be.
And what about this whole thing about next of kin? I've recently had hospital treatment. They asked me for my next of kin.
Yeah.
Does that person not make those decisions?
See, next of kin is a very strange concept, because there is a belief that it's a legal term. It's not actually a legal term. It's actually a way of, when you are in hospital, the hospital need to know who they need to contact about things that are happening in the hospital setting. So that's where it's come from. That's your next of kin. So you can say to the hospital, my next of kin is my daughter or my son or my husband, something like that. But it's not a legal term. It's just a term that's used, is slightly misused actually, because there's no legal basis to the term. It's just somebody that is notified that something's happening about you.
And we quite often come across it within the work context. So quite often when you join an employer, you'll be asked for your next of kin. And we come across it where an employee doesn't turn up for work, and then the HR team are saying to us, oh, shall I contact the next of kin? But equally, you can have death in service, can't you? You can have bereavements. We have them from time to time, more often than we'd like, really. And we're often asked by HR people, well, what happens about the final pay check for this person? Do I just send it to the next of kin?
Yeah.
But the next of kin doesn't have any sort of responsibility or entitlements at that point. They're not the same as the beneficiary under a will or something of that sort, are they?
Yeah, so basically, as I say, next of kin is that person that is contacted, that, you know, that the person you make a phone call to say, we've got this situation going on. And so in the workplace, that would be that, that's you informed that, let's say you've said, you know, your employee has tripped up and they've hurt their leg. Your next of kin, that person that you contact, is that telephone call to that person. It's the notification of something that has happened. But when somebody dies in service, that's a next of kin doesn't have any legal rights. They're allowed to be consulted, but the legal rights fall to the people that are the executors of a will. And if there is no will, it is who are the administrators under the statutory intestacy rules. And that might not necessarily be the person that isn't the next of kin. Because the next of kin, let's say, for instance, an example, that you are cohabiting and you're not married, but you're living together. That person is your next of kin for this, you know, communication. But if you haven't done a will and you haven't appointed that partner as your executor, that partner is not necessarily, well, is unlikely to be your administrator, because the administration rules go down the family line, the bloodline. So potentially that person that you're living with isn't going to be the decision maker or actually entitled to that check that you referred to of the last payment. It would be somebody completely different. So it's very important is to know the distinction of, if somebody did die in service, is who is got the correct legal entitlement to have that last payment check.
And is there a way that HR people can find that out at all?
I mean, my advice would be is that obviously you would be having discussions about the death in service and the pension and things like that, and your employer will do that nomination, etc. But maybe potentially ask them, have you got an up-to-date will? Have you got a power of attorney? You know, who, if anything happened to you, who would be your administrator? Who would be your executor? You know, because maybe it's really important to have that, maybe on a checklist or a questionnaire or something. I don't know.
And then ultimately, if the worst comes to the worst and you get that call saying that something has happened, somebody's passed away, they've had an accident, they've not recovered from an operation, whatever it might be, you could potentially ask the person, well, in order to process the affairs that we need to deal with at this end, we need to see the will, presumably, or we could see the
potentially,
will?
you know, it depends on how you look at things, and I suppose some of it is also what the value of the asset potentially might be to an estate, because they might want maybe something like a grant of representation, either a grant of probate or letters of administration. They may, if there's a will, then that might be helpful. I suppose it depends. If there is no will, then possibly you might need a grant, a letters of administration, to prove that that person has that legal entitlement to receive that money. Because I think I certainly have seen it where things have gone wrong, where money has been paid out to people that are not legally entitled to receive that money, and it's gone to them or they've claimed it. Sometimes the banks pay out under what's called a statutory declaration, and that person wasn't legally entitled, and then I've had to go and, on behalf of the true beneficiaries, I've had to go after that person for recovery.
So, and then we've got litigated probate work, then I presume contentious probate work at that stage.
Absolutely.
So you must find that you're dealing with quite traumatic situations, or potentially traumatic situations, people's lives. You're talking about death and bereavement and incapacity and dementia. These are all really challenging topics. Any tips for our HR audience on how they handle those issues?
I think it's just having conversations, with their employees, and just making sure that, that they get the support that they need, the families get the support they need, making sure people's affairs, advising their employees to make sure their affairs are in order, so make it easier for them and their loved ones, and also the firm or, the employer, and just make sure that it's reviewed as well. It's like maybe every 5 years or something, just have a review with, is everything okay? Just making sure that everything is correctly documented. But I think if there is somebody that, I think one of the problems is that, the employee, if they've lost a loved one or their parent or whoever is losing mental capacity, it's very traumatic, can be very traumatic, and that pressure on that employee can be quite intense. Bereavement, especially if it's a very close loved one, and to be understanding and supportive as much as they can be, I think.
And how do you maintain your own resilience dealing with all those sorts of... You must spend the whole time thinking, well, what if this happens to me? How is this going to affect me?
It's really tricky. It's that balance, isn't it? I mean, I've been doing this job for 24 years now, and I think you want to do your best for clients. You want to help them, and of course that's our job, to do that and get them through the processes. But it can take a toll, especially when, like, I certainly have, my family have been through a bit of a ringer this last year as well, and it's that balance, and it's trying to sort of keep sane and sort of like keep calm, and carry on to a certain extent. And that's all I can sort of say. It's just like,
take every day as it comes and see how you get through it.
Exactly, that's all you can do, isn't it? Take each day as it comes and just do what you can, and don't be too hard on yourself, I think.
Very, very wise indeed. Any final words of wisdom or encouragement? Any top tips you'd like to share with our audience?
I think the biggest thing is for me is have those conversations, have those really difficult conversations, potentially with your family, or encourage your employees to have those difficult conversations with their family, because if you haven't got it written down or you haven't relayed those information, how does anybody know what you want? How if you particularly have strong views about something, a lot of people have strong views about blood products or medication or even financial ethics. Some people don't want investments in certain sort of crypto or whatever, and I think it's having those conversations. Say, I wouldn't want that to happen. I wouldn't want to go into care home. And a lot of people wouldn't want to go into care home, but sometimes it does have to happen, unfortunately. But have those open conversations. Talk to your family. Have those difficult conversations. What would you want if, you died? Because a lot of people shy away from that conversation around death. But if you've got a really strong wish or belief, then just share it. Just share it with people, or write it down, and just seal it away, so at least somebody can find it and say, that is what that person wanted.
I remember watching an episode of Martin Lewis, money saving expert or money supermarket, whatever he is.
He's
financial guru.
He's very pro in this area.
He was very much saying that, the legal sector, the banking sector, we're all pushing wills. We all talk about wills all the time, but really powers of attorney are the thing that we need to be getting the message across about. That people really, that's the thing that's really going to affect people's lives and make a difference to people. And that's what they should be focusing on, really.
Yeah, absolutely.
Very interesting talking to you, Karon. You have watched our podcast, so you'll be well aware that we end the podcast with an audience-sourced question. And we have it here. So the question for you is in this envelope. Over to you.
Okay, here we go. What is the best piece of advice you have received? Crumbs, that's a really difficult one, isn't it? I think probably is not to be too hard on yourself. I think is just keep going and just keep calm, because you always come up with huge amounts of challenges in your life. Personally, in work, there's always a challenge. It's just to try, if you've had that bad day, which you will have, everybody will have that bad day, is keep calm, carry on, because tomorrow's another day and it hopefully will be brighter.
Well, that's a very positive note to end on. So thank you so much for your time today, Karon. I really appreciate you coming on the podcast, and I look forward to carrying on our conversations on another occasion. Thank you.
Great, thank you.
Thank you for joining us for today's episode. I hope you found it insightful and empowering. To stay connected, why not hit the subscribe button? Or if you think your friends might be interested, why not rate us as a 5? To be first to know about upcoming episodes, follow us on Facebook, TikTok, Instagram and LinkedIn, where you'll find us at Warner Goodman LLP, or follow us on YouTube, where our episodes are at Piece of Pod. Thank you again. Until next time.